Hey, thanks so much for joining me. I'm here today with Mehul Gandhi from Westmount Wealth Planning, and we are going to talk about some of the common considerations that come up for business owners when they are engaging in financial planning. So thanks so much for taking some time today to discuss these topics.
It's my pleasure, Steve. I know that we've talked about doing this for some time, and you and I have had these discussions at length, and it's nice to be able to share this information.
Yeah, no, absolutely. Okay, let's just get right into it. Some of the things that we were talking about offline were the shareholder agreement. So this is something that I think business owners hear about a lot, and they don't necessarily know exactly what it means, when the right time is to put it in place. And if they do have it in place, then is that enough? I suppose before we get into the nitty gritty, because we were going to talk a little bit about insurance and how that dovetails with a shareholders agreement. Why don't we just talk about, for what type of business is a shareholders agreement appropriate, or perhaps more than appropriate, a really good idea or required?
Yeah. I won't pretend to know more about this topic than you, because this is a big part of what you do and what you recommend to your incorporated and business clients. In my mind, I think about business, getting into business with another individual as a relationship. And I think you would agree with that. And in any relationship, for it to be successful, especially when there are assets and money involved, it's a good idea to set out the rules of engagement beforehand. And that's essentially what a shareholders agreement is doing, very big picture. Like if we were to really distill it, we're setting out the rules of engagement of how certain business decisions are made, how the business is owned, how assets are to be treated, how risk is to be managed, how we plan for worst case scenarios, day to day, even just banking, all these sort of things that can be captured in a shareholders agreement. Now, I think if you are in business with another individual, it is very important, I would even say necessary or mandatory, to have some type of an agreement in place. And certainly if you are incorporating as an entity or even as a partnership, you should have a shareholders agreement in place that are always going to stipulate, there's always going to be this sort of boilerplate version of it to start off with, because you got to start with something, but then adding in the different facets that are specific to your particular arrangement with your partner or partner. And again, as you layer on more partners, 3, 4, 5, multiple partners, this becomes even obviously a bigger, more complex document, and therefore that much more important. To answer your question as to when should you get it, I think as advisors, we would say the earlier, the better. But I can certainly, as a business owner, understand why business owners may avoid this or put this off initially. There's so many things going on when you start a business. Like you have this idea that you're excited about and you want to capitalize on it. So it's like, I don't want to deal with all this other sort of non-business stuff that's not related to my idea getting out there. I'm just going to push this off. We're not really making any money. There's nothing really to discuss. If anything was to happen tomorrow, who cares? It's all good.
Yeah.
But what happens is when you push stuff off and you procrastinate, all of a sudden you realize, you pick your head up, you've got this super successful business, you have a bunch of assets, a bunch of money, a bunch of retained earnings, and you don't have any rules around it. And now you're trying to create these rules with another individual or individuals, which when all this is at stake, things can change emotionally, psychologically. A certain amount of greed or opportunism can come out of individuals, which might not have existed when you created this rules on a very sort of level plane before everything started. That's the way I see it.
Yeah. No, exactly. I think the clearest analogy that can be drawn is either to a will or to a prenuptial or a marriage agreement. Those are, it's a blend of both in a sense, because a will is designed to deal with the eventualities of life. Everything that comes into existence will eventually cease to exist. Same goes with business. No business is perpetual. There might be certain dynasties that last a very long time, but that's the exception, not the rule. And the reality is that business is a very dynamic relationship. And some business relationships might last for 6 months, they might last for 6 years, and some are not really going to go anywhere, and some are going to be incredibly successful. But whatever the outcome is, you want to be able to have an idea of how things are going to play out. And just like you're saying, people don't really think about it until it doesn't matter until it matters. And then it really matters. By then it's a little bit too late, because the ability to negotiate and set the ground rules with a clear head, without the emotionality involved, is much, much easier to do at the beginning stages of a business venture.
Agreed.
So, and also apart from just having disagreements that arise inside of a business. There can also be unexpected events. A shareholder could become disabled. The business may choose to expand rapidly, or it may be acquired by another entity. So these are all sort of events that would have a direct bearing on the rights and responsibilities of each shareholder, and anticipating some of those events and planning for it is responsible business planning, essentially. I think because there are so many aspects to a shareholders agreement and so much thought needs to go into it, there are legal implications, there's financial implications. It can be an overwhelming conversation, which of course is why there are professionals who have spent thousands of hours pouring into these documents and thinking through what works and what best practices are out there. I want to turn to one of the main risks that a shareholders agreement is hedging against, which is the death or disability of a key member of the business. So somebody who is a driving force, C-suite member, they also happen to be a shareholder as well. So perhaps they're one of the founders. And in many small businesses, if one of those persons were to pass or become disabled, then that could really imperil the entire business and perhaps even kill it off altogether. So with that in mind, a shareholders agreement they often include provisions called a buy-sell agreement or a key person insurance. Why don't you share a little bit more about that? How have you seen your clients approach that? And what are some of the recommendations that you would make to, let's just say, a business that has 4 shareholders with 4 individuals who are all key drivers of the business?
Absolutely. Such an important topic. So the way I like to approach this and the way I usually start this conversation with business owners is, tell me about your experience with your business acquiring lending. When have you had to acquire lending, whether it be a line of credit, some type of a mortgage or a loan? How has that experience been? And most often the answer is, it's a bit tedious. It can be frustrating. Maybe they didn't get the lending they required or wanted. Maybe they weren't approved for the amount, or maybe they just didn't have the history or couldn't provide the security to the lending institution to really get exactly what they wanted. And so liquidity, and that sort of drives us to the next topic of liquidity. Businesses are always after liquidity so that they can expand, whether that's through credit, whether that's through cash. And historically, up until most recently in a low interest environment, credit's kind of been the way to go, right? Put your cash to work, especially if you're making a healthy ROI on that, and borrow to expand, utilize that lovely word leverage. Knowing how hard it is to acquire credit when your business is healthy and going and all your business partners or your shareholders are there and present and working in on the business. Imagine what it would be like to attain liquidity when one or more partners was no longer there due to either an untimely passing or a horrible accident, injury, or illness where they are not able to work in the business anymore. Mm-hmm. Right? You're now scrambling for liquidity, and we'll get into why you might need that liquidity at a point where your business is probably not at its best, let's say. Not necessarily at its worst, but definitely not at its best. Institutions are going to definitely look at that and consider that when they are deciding whether to advance you that credit. And you're also probably going to second guess or really think about, do you want to use your cash reserves in this instance? Because you don't know what the certainty is going forward. There's a lot of uncertainty going forward, and it's best to keep your powder dry. This is where insurance plays such an important role. So if we take the basic example of a shareholder unfortunately passing away prematurely or unexpectedly, typically what happens in a very sort of vanilla cornflakes example, the shares of that individual are going to transfer over to either the surviving spouse or more commonly the estate. So let's just go with the estate route. Everyone can understand that. You and I are in business, I pass away, my shares roll over to my estate. And then maybe my spouse now acquires those from the estate. And we won't get into the taxation behind that, it's beyond this conversation. But the fact of the matter is you're now in business with my spouse, who has no idea about the business, who has no desire to be involved in the business. Really what you're after is full control of the business. So 100% ownership of those shares. You want those shares from my wife. And my wife really wants the fair market value of those shares so that she can go and get on with her life. Yeah. If you don't have the liquidity to do that in that moment, this becomes troublesome, right? Do you have to buy her out over time? What happens during that time? Are you able to go out to an institution and say, hey, listen, I need to borrow X amount of dollars, hundreds of thousands, millions of dollars in order to buy out this individual. And I start selling assets in order to do that. It's a very tumultuous and difficult thing to do. What if there was a life insurance policy on me, which our company owned and was the beneficiary of, so that such that when I passed away, that death benefit actually was injected into the business, and you were able to use that to acquire the shares from my estate or from my surviving spouse, right? Again, the mechanism in which that happens is there's different ways. There's like 2 or 3 different ways that you can actually do it. It really depends on your initial setup and what you're after and the scenario at the time. But in a very basic way, you're basically going to give my spouse a promissory note, a post-dated check, so to speak, a really big one. And you're going to be able to acquire all the shares. You're going to have the death benefits going to come into the company. You're going to be able to pay that out through the capital dividend account to yourself as the only shareholder as a tax-free dividend. And you'll be able to utilize that to purchase the shares for my wife and now be in full control of the company, sole shareholder. Yeah. And she now has the fair market value of those shares, or at least hopefully as close as possible to it. Yeah. Now, we talked about the onset of doing things at the right time and not doing them when it's too late. There's no better example than life insurance. You obviously can't get insurance on someone once they're dead because they're dead. And it's also very difficult to get insurance on someone who's already come down with some type of medical issue, is uninsurable now. It becomes very difficult and very expensive if it's possible at all. So it's one of those things where it does not have to be expensive. We're not talking about any kind of fancy cash value whole life insurance. Typically, a really good, solid, inexpensive term policy will be great in this situation, depending on the plans of the business. If the business owners have already planned for an exit 20 years down the road, then hey, let's use a 20 or 25 or 30-year term to secure that coverage, and it doesn't have to cost a ton of money. Yeah. So that's probably where we would start. Now, this is considered to be a buy-sell type of, this is insurance that's going to be used to purchase the shares or buy the shares that are going to be sold by the other shareholder, which in this case is my surviving spouse in our example. That will differ from a key person policy, right? Now let's shift gears, right? We're in business together. I pass away. I happen to be the main sales guy, right? I'm the guy that goes out there and acquires all the contracts to sell our widgets to. Okay. And really, the main revenue is being driven by, if there's no sales, obviously, Steve's the engineer of the widgets here. He's got nothing to really create if I can't go out there and drive sales. Let's just forget the share of my spouse and all that, the previous example, but let's really just think about the immediate effect on the business. It's pretty obvious in that very simple example to realize that there's an immediate impact on the revenue of the business right off the bat. Right? Who knows? Maybe certain contracts start getting canceled because I had relationships with all these people out there, all these individuals that were, our clients rather, and they go elsewhere. They go to our competitor, right? This creates a real situation and a real problem for the future health of the company, and it could impact you immediately. So now this would be a key person type of coverage. What should have been done is, upon realizing who the key people in the business are, you can take out, again, a very inexpensive term policy on that individual in order to make sure that if they were to pass away prematurely, there is some liquidity coming into the company. Maybe it allows you to hire someone temporarily until you get your feet under you. Yeah. Maybe you want to get your business ready to sell, but you do need to bring someone in because typically it takes a little while to just go and sell a company. There's some things that need to happen in advance. It buys you some time. Let's go back to that old saying, I think it was Mike Tyson, thinks they're ready and they're prepared until they get punched in the face, right? Yeah, for sure. And the things like that are a punch in the face. They knock you back, they get you back on your heels. And what you really need is just time to get your bearings back. And that's really, in this case, what the insurance is affording, the life insurance is affording.
So Mehul, if you're a shareholder who is a key person, do you need both insurances? Do you get a term life over yourself as a shareholder of the company, as well as key person insurance as well? Is that?
Yeah, definitely. So if you play both rules, there's the buy-sell aspect of it. There's a key person aspect of it. You're definitely going to want to make sure you have enough coverage to satisfy both requirements. Whether you do that in one blanket policy, to borrow an American term, versus 2 separate policies, that will be dependent on the situation. Right. A lot of times I will recommend 2 separate policies. Yes, you're going to double up on your policy fees, which in a case like this is nominal, but it makes things just cleaner. You can imagine
it's for 2 separate purposes.
two separate purposes. Corporate minute book can reference two separate policy numbers. This is for that. I think even CRA would probably like seeing that, and if there was any type of legal issue there, it would be really nice to see those two separate policies being earmarked for separate usage.
Yeah. One is to make the spouse, the surviving family members, the deceased shareholder, and to ensure that the remaining shareholders have full control of the company. And then the other aspect, the key person insurance, is to ensure that there's enough working capital to continue to hire appropriate people with the appropriate level of skill and talent to keep the business rolling.
Exactly. And one other thing I would note is that, again, going back to what type of life insurance is adequate or is appropriate for this, again, I really go back to some simple term insurance. And if it is something that needs to be long-term, if you can't determine what's the perfect length of term, so you go for something, what we call a term to age 100. So it's a term policy in the sense that at age 100, it'll last all the way until age 100, but there's no cash surrender value. There's no investment component to this type of policy. And this is important for tax reasons, right? You typically don't want to hold a passive asset like a cash value permanent insurance policy in an operating company, right? That's a non-active asset, non-active income producing asset in an operating company, which if you choose to sell in the future, you run into these purification rules, especially if this cash value starts getting really big. So
throws you outside of the
throws you
capital gains
outside,
exemption.
And so you definitely want to make sure that you've got the right type of insurance policies in the right corporations. The cash value stuff, save for the holdcos and things like that, or personal ownership. And I've seen this happen before where you run into this issue where the wrong policy is in the wrong corporation, and now you're looking to have to transfer it out. And that's a whole other set of issues.
Simpler said than done. Yeah. So corporate insurance transfers. Talk to me like I'm 5 years old. What is a corporate insurance? It sounds watching paint dry on this topic, but
oh gosh, yeah. You know what? This is riveting stuff, Steve. I assure you. I mean, it really just follows up on what we were just talking about. You have an insurance policy, typically with some cash value. So we're looking at a participating whole life policy or a universal life type policy here in Canada, which have acquired or have grown in cash surrender value or cash value over the years. And it's essentially, and it is technically an asset on the company's balance sheet.
Yeah. Because each year it grows as you put in more premiums, you put in 10,000, 15, whatever the amount is per year, cash value grows.
Correct. And those two policies, universal life versus participating whole life, work differently, but they both have a growth component as well as a insurance component to it. Right. And both will act as an asset on the company's balance sheet and will actually act to increase the value of the shares of that corporation as the value of the cash surrender value, underlying cash value grows. So these are very much a part of your asset list in that corporation. And again, you want to watch for, are you holding these types of policies in the right corporation, the holding company versus the operating company? Now, we have run into different instances where individual professional corporations like physicians, lawyers, maybe optometrists, things like that, where maybe not so much optometrists, but think of professional businesses, even real estate professionals, where they don't really have a sellable business.
Sure. So it's tied to them. It's tied to the face of the business.
There's no way they're going to turn around and sell it. And they're just going to end up winding it down when they quote unquote choose to retire.
Sure.
And in that case, for whatever reason, it seems like a very simple idea. Let's just own that cash value life insurance in that operating company, in that professional services company. So because
they're not worried about
sell it anyways.
They're not worried about getting the capital gains exemption.
Correct. Exactly. And that's all well and good. It saves you some fees on opening up a holding company and some filing fees every year and all that. And it keeps things simple.
Sure.
But what happens when you are ready to wind up that medical corp? You're no longer a doctor and you want to shut everything down and you actually want to own this policy personally, right? Let's say that the bulk of your income now is outside your corporation and you want to fund this thing, or you have another corporation altogether and you want to move it to another corporation. Remember how I said that these things are actual assets with value to them.
Yeah.
Anytime you transfer something, there's a disposition. Even if you're not going to quote unquote pay the value, there is going to be a deemed disposition and is going to trigger some tax. So really look at, if you find yourself in this situation, you really have to look at, okay, how do I transfer this? What is the actual value of the policy? And I'm going to really make this riveting in a couple of seconds here, but how do I transfer it? What type of tax is going to be triggered? how do I actually file this? Does this have to go on on any type of tax filing, income tax filing, either at the corporate level or personal level when I file my taxes every year? All these considerations have to be made. Are there some provisions in the income tax that can allow for a more favorable transfer, a deemed dividend, for example, things like that? Is my business set up for that? Do I have that ability? So many things to consider. Taking a policy and just changing the ownership, the insurance company, to be honest, it's not their responsibility to be the overseer here.
Yeah, they're not your accountant.
Not your
financial
accountant.
advisor.
They're not going to take the
Not your
liability.
lawyer.
Absolutely not. And neither do they want to be. So
Yeah.
they will provide the forms. If it's a title change form or change of ownership form, they'll ask you some questions. They'll assume you're answering the questions correctly, and you'll submit them and they'll make the changes. If CRA comes a knocking and things aren't done properly, then you'll see the result of the actions. Not to be, not
So
to be dramatic.
is this generally addressed on a rollover basis? Is
Could
this
be
a tax rollover
uh,
situation,
it
or
could,
is
it
this?
could be addressed on a rollover situation if you're doing some kind of a reorg, basically opening up a new company. You can also push it out as a deemed dividend if you have the ability through your corporation. Those are, if you have a CDA credit, maybe you can push it out as a tax-free dividend. There's some CDA credit allowed.
Whatever it is, you need to
leftover.
get some advice.
Whatever you need to do. You need to get advice. Now, this is where it gets interesting, right? And this is actually, I think, I find this fascinating. So remember I talked about the basic term insurance with no cash value?
Yeah.
One would think that you can transfer those and there would be no tax trigger because there's no cash value.
Yeah.
The way the language that CRA uses is that the deemed disposition, the value of the policy is actually a fair market value, which is not restricted to just the cash surrender value. So let me ask you a question. You have a term insurance policy. You are a healthy individual. It's a term 20 policy. You're in your 40s, say, and you're very healthy, no issues. And that policy, you've had it for 10 years. There's 10 years left on the policy. What are the chances that policy is really going to be paid out? Pretty slim.
Yeah. I have to ask an actuary, but
I'm glad you said
hopefully,
that.
Hopefully less than 5%. I don't know.
Hopefully small enough that the value, an actuary would probably say the value of that policy is nil. You can transfer it, and we're pretty certain there's not going to be any taxation here, any tax triggered, and we're very certain that CRA is not going to assign some type of value to this term policy. But if you are a couple of years away, you're older, say you're in your 70s, you got this term policy, you're of very poor health, right? And now you're transferring this policy, and it's pretty eminent that in the next 5 years, this thing's probably going to pay out. What do you think the fair market value of that policy is? Not zero.
Right. Perhaps closer to the actual payout value.
Potentially.
Yeah.
So that's where I would say things can get a little bit complex.
And that's interesting because the taxable value, like you're not the beneficiary, right? Like the person who owns the policy, it's the spouse or the child or a sibling, something like that.
Yeah.
And yet you as the owner have to deal with this taxable disposition,
or your corporation or whatever,
or the corporation, whatever, whoever the owner is. Yeah.
So it's an interesting thing. And like you said, what you need to do besides talking to an accountant, getting advice from an accountant or a tax specialist is definitely, if the tax specialist isn't recommending it, you should definitely go ahead and get this thing valued officially by an actuary. And we can link some of the more notable actuaries in town that do this that we've used before. And it's really important. Yeah, you pay a little bit, but we're usually doing these kind of things in part of a larger plan. So this cost is nominal, right? You consider all the other costs that are associated with this. It's a nominal that are going on with the entire strategy you're trying to execute on. This could be a nominal cost, but obviously compared to what the cost of the tax bill could potentially be with CRA if you get audited.
The fines and the penalties. We come across this all the time, of course, in corporate reorganizations. Clients come and they've set up a business, maybe it's a dental practice or what have you, and then they've got to the point where there's enough retained earnings that it starts to make sense for a variety of reasons to insert a holding company or perhaps a family trust. And then there is a transfer of the asset. There's a taxable disposition. So usually it makes sense, and almost always, to get a professional valuation of what is the actual value of this practice. And yes, there is a cost to that, but there's a clear benefit to it. You're going to sleep way better at night knowing that you're not beholden to some kind of future unknown investigation by the CRA and the consequences that might bring.
Absolutely. I think that I couldn't have said it better. You want to sleep at night. You're doing all of this to serve some kind of purpose that's going to better your situation, whether it's from a tax perspective, whether it's from an estate planning perspective. Why just execute on 99%? Like, do that last 1%, dot the I, cross the T, make sure you get a proper valuation, an official valuation, pay for the thing. And now you know everything's been done properly, and you're essentially not going to shouldn't run into an issue going forward.
The family cottage. So maybe hit a little bit of a curveball for you, but family cottage, this is something that comes up time and time again with business owner clients. And a lot of people have cottages. Maybe they've inherited it or they've bought it during their lifetime. Say you've got two parents, and they've got 3 kids, and they've got a cottage over on Bowen Island. How do you approach this? Like, what are some of the first questions that you're going to be asking your client about how they want to deal with this? And what are some of the key traps that people can fall into if they're not careful?
Absolutely. So there's 2 questions that I see often. One is, we want to sell this thing. We're ready to sell it. No one's using it. Kids aren't using it. We barely go up there, and and it's appreciated significantly. We want to sell it. Yeah. Can we use our principal residence exemption on this property?
Yeah.
And again, I don't want to get into the actual calculations that go into this thing. But what I will say from a simplistic, very high level is, you can only use, if you have multiple properties that you use, so say let's call in this situation an actual home you live, cottage, you can only use one property in a given year as your principal residence exemption. So if you are claiming the principal residential exemption for, say, the past 20 years, then your home where you live in cannot be your principal residence for those 20 years. You can't double dip.
Yeah, you could just switch it out.
Yeah, you can't just like, oh, this time around, that thing I said last time. Nah, I changed my mind.
Yeah, I was kidding.
That's not gonna happen.
Yeah.
And then there's all sorts of crazy things that people, what if I just divorce my wife and put her and she business? Like, come on.
And then she could have her own PRE.
Yeah, like CRA has never seen this before. They're just like, oh, you're just going to pull the wool over their eyes. Not going to happen. In that case,
the reason that the Income Tax Act is this big.
There's that too. Yeah. It's not just, there's actually stuff in there.
Yeah.
So from that perspective, first off, it's better to start planning sooner. If you know you're going to be selling in the next couple of years, let's start looking at where is it most advantageous, or what years is it most advantageous to claim the principal residence exemption. Which property is it most advantageous to use it on? Are you planning to sell the other property that you own at some point in the future? What's going to trigger a bigger tax bill? There's, it's pretty simple spreadsheets that can be created to weigh the cost benefit and pros and cons to let you know which way to go. That's that. Okay, so that's selling. The other side is, I don't want to sell. We love this thing. I inherited it. Now I'm passing it on to the next generation. How do we do this? Right? Should I put my kids on title? Should I put one child on title? Should I put them all on title? Should I put it in a trust? Should I do this? Should I do that? How do I make this happen? Because remember, let's say it's not a principal residence. So there's no exemption available on this property, or it's not going to be utilized. The family's opted to not utilize the principal residence exemption. In that case, then there is going to be a disposition on death, a taxable disposition on death, right? Sure, first spouse passes away, it can roll to the surviving spouse in a rollover, that's great. But when it's going from G1 to G2, generation 1 to generation 2, we are going to have a disposition on it, because there is no exemption. And we know that it's the value of that property immediately before death minus the adjusted cost base. In most cases, whatever it was purchased for, however much it was purchased for, that's your capital gain. As it stands today, I haven't read what the budget has said fully, but last I checked, 50% of that gain is included in your taxable income for the year, and that's what you pay. And now it rolls over to the next individual, next generation at that new fair market value, becomes a new adjusted cost base, and so on and so forth, the G3, G4. That's great. That bill can be significant, right? Remember which part of the world we're talking about here, right? This is Vancouver Island, this Bowen Island, areas like that. These properties could have been picked up for a very small price 20, 30 years ago and have appreciated significantly. So we are looking, it can actually end up being one of the biggest assets in your estate. and therefore generating one of the biggest tax bills for your estate. The simple answer, the simple solution there is, should we get some life insurance on the parents so that whether that's individual or joint last to die, so that there is, again, some liquidity to take care of that tax bill and everything rolls over nicely.
Yeah. And is that a practical solution if the parents are, say, in their 60s or 70s? Because
it's not going to be the most, we have to weigh it. We're going to weigh that against what are some other solutions. Is there, because we can't eliminate the tax altogether.
Of course.
Right? There's no way to make that tax disappear in the scenario that we're describing.
Like when both parents die, because there's a spousal rollover, of course, but eventually that generation is going to go.
Correct, especially if there's no principal residence exemption available for that property. So in that case, could you cap it? Could you do some planning beforehand, like an estate freeze or something, roll that into a corporation, do an estate freeze or trust, and then really cap that tax bill for G1 and then future growth to G2, something like that. Can you start adding kids on title? You can, but there's some other sort of family law considerations around that. If any of your children enter into a relationship, they bring their family to this property now. So it's now become essentially can be considered part of a family property, matrimonial property. If they end up getting a divorce, now that's on the chopping block, that piece of property. There's a lot of considerations.
Or what happens if one of your kids gets sued?
Creditors
if
coming after
creditors
it.
come after them, then
Totally. So there's so many things to consider besides just the tax implications. And it really goes to this saying that is quite common in the tax communities. Don't let the tax tail wag the dog.
Sure. Yeah.
If we make every decision based on minimizing tax and minimizing probate, there can be some unintended consequences that can really make things more difficult overall. And really, the cost of the tax was not worth the predicament you're in as a result of. Life insurance can definitely be a solution, but if you have older individuals who are potentially uninsurable, then it might not be worth it, right? If you want to now go into some other planning, that's something that you can look at, right? Joint ownership, and like I said, an estate freeze, those are things that can be done. But again, you just have to be careful to know exactly what the consequences of that are. Yeah. So it's an interesting problem. It's a common problem that is there, and one that I like to address, especially with younger couples who have younger kids and they're still insurable. The insurance is still very reasonably priced and they can do this. I think that's a good still. One thing I do run into sometimes, which I get a little bit worried about, is seeing properties like this in a corporation. The reason is, unless this property is really being rented out for income, for essentially most of the time, like almost all of the time, this is a rental property. If it's being used in a significant amount personally for family, then CRA has a problem, right? That can be very much seen as a shareholder benefit. And the way they penalize shareholders for that is actually a lot more punitive than we might imagine. The way they look at, okay, it's not just, hey, what would the cost of Airbnb or renting a cottage like that for a night be? And they'll tally that up, and that's essentially the value of the shareholder benefit. No, it could also be looked at that property wasn't purchased by your corporation, and that money was actually used to invest in something else, like other investments that you've made in this corporation.
Yeah. And
that generates X amount of return. What type of tax should we have been owed CRA based on that investment? They can actually look at it like that.
Yeah, no, I see that a lot in my practice. Like clients come and they have properties that they are considering rolling over into a corporation, or they want to start a corporation and then start purchasing properties inside of that vehicle. And that can make sense. It certainly can make sense. There are some benefits there, but I think there are some sort of fundamental tax reasons why it may not be the most attractive option. One, like I think some people are under the understanding that it qualifies as business income. And of course it does not. It's passive income. So it's going to be taxed at the highest rate. Really, from a tax perspective, I think the only reason to do that is that you have the ability to start with a higher amount of working capital.
Correct.
To purchase those properties, because you say you're earning millions of dollars inside of your operating company. You pull that out in a dividend to your holding company, and then you can use that money you'll have more to start with, because that income has been taxed at either the small business deduction rate of 11% or the general rate of 27%.
That's right.
And
So more after corporate tax dollars, which that's the big thing, right? When I see a whole whack of retained earnings in my corporation, I want to use it in there. I do not want to cross that personal tax threshold and have it filter through there and have a good chunk of it taken away. And now I have less to invest, purchase that property with. Brought up a really good point, right? I always caution owners, especially if they have children, to be like, okay, what is the financial situation of your children right now? If, let's say it is owned by a corporation. Let's say this is not even a cottage. These are rental properties, so to speak. And you have bought them, everything's fine, and you want to pass it on to the next generation. There's maybe 2, 3 apartments, whatever it might be. And now you want to pass it to the next generation. And I'll always ask, do you think that the next generation, that your kids are going to maintain these as rental properties? Or do you think their need or desire is going to be to sell those properties and get that cash to themselves because they are in need of that cash? Whether it's because they're in debt, whether it's because they need to do a renovation.
They want to buy their own home.
Buy their own home and they need $300,000 down payment or whatever it is. Right? If that's the case, then we really want to go through how that is all going to be taxed. Because now you run into this double, potentially triple taxation problem that happens when you have assets like that in a capital assets or real assets in a corporation. Because now you have the deemed disposition of the shares on debt. So that's going to trigger tax. You're going to have the sale of that property inside the corporation, which is going to create a taxable dividend inside the corporation or a taxable gain inside the corporation, right? Yeah, you're going to get a bit of a CDA credit for half of that gain. But when that money does come out, the taxable portion comes out, it's coming out as a taxable dividend.
Yeah.
You tax this thing 3 times, you can erode the value of that property from anywhere to like 50 to 70%. Is that really what you want to happen to this?
Right? Unintended consequences, right? Absolutely. Yeah. Can't really stress it enough that how important it is to get tax advice on this. But I think also even more fundamentally, to have these conversations with your family and really understand what are the objectives of your children, what makes sense for them. Because I think a lot of times estate plans and perhaps insurance plans as well get put together without having those conversations for whatever reason, because perhaps people aren't, the clients aren't comfortable talking about money with the next generation, and fair enough, or with really addressing mortality.
For sure. It's not,
but for whatever the reason is, it can really create some undesirable consequences that nobody really foresaw.
Absolutely. But I'm hopeful, Steve, because just the plain fact that you and I are having this conversation demonstrates how much our industries have shifted in the last few years. I think one of the other contributors to these types of situations occurring is advisors work in silos. They don't talk to one another. So the lawyer or tax planner, corporate lawyer, estate planning lawyer is not talking to the financial planner, is not talking to the accountant, is not talking to, if they have a CFO or a controller, whatever it might be. And it's really, we're in a great position as advisors to be able to really say, hey, listen, I'm going to play quarterback on this. I need your other advisors in this meeting with us today. Right. I'll even pick up the bill on that. If I need your kids in this conversation today, I need your spouse here today. This is not me and you having this conversation in a corner and making some decisions without asking everybody else. And then all of a sudden we've created more problems than we've solved. And I am hopeful because I have seen this trend in the advisory space, the financial advisory space, including tax law, estate planning, all of that, where we're starting to come together and realize that it's not about us and our egos, it's about the client. And I think that's where we are the most valuable, because 1 + 1 = 3 in these cases.
Yeah, no, 100%. Yeah, couldn't agree more. Okay, is there anything else you want to touch on before we wrap up? I'm sure you got a busy day, keen to check out what the budget is, et cetera.
I have to always say, we've mentioned life insurance quite a few times in our conversation. So, we've mentioned life insurance a bunch of times today, but no insurance conversation in my mind is complete without talking about what if you don't die scenario, right? A lot of times, especially for younger individuals, whether they're in an accident or come down with a serious illness, they survive, but there's a cost to that. There might be an extended period of time where they're not able to run their business, work, generate income, things like that. And it sounds sad to say, but a lot of times survival can be more expensive than passing away. And so that's why I always take it upon myself to bring up the living benefits. So whether that's disability insurance or critical illness insurance. And one of the things that is really important to touch on, I find that people aren't so aware of, is for business owners, especially if you have employees or partners who are active in the business. So going back to these, let's say we've got these 4 partners who are active in the business, say it's a law firm, say it's an accounting firm, or whatever it might be, engineering firm, and they're all active in the business. And maybe they have a group benefit plan with some LTD. Maybe there's a $5,000 LTD benefit, long-term disability benefit with that group plan. That's great. If these individuals are earning $20, $30, $40, $50, $60,000 a month, that $5,000 LTD plan is not enough.
Not going to cover the mortgage.
Right.
Yeah.
So what we can look at is taking a very personalized private disability plan that's customized to the individual's needs and bringing it into a corporation. As long as we have 2 or more individuals who are active employees in the business, drawing salary of the same business, at least 2, we can now turn these private disability plans into what's called a wage loss replacement plan, which is just a fancy term for corporately owned private disability insurance.
Yeah.
It is disability insurance. It's owned by the corporation. The beneficiary is still the individuals. It is a taxable benefit to the individual. So we have the ability to gross up that benefit. So the after-tax net amount is comparable to what they need. Is equal to what they need. And it's a tax deduction for the corporation. And in the cases that works and we can set that up and all the boxes are checked to be able to set that up, it ends up being quite advantageous compared to just a standalone private disability plan outside the corporation. And statistically speaking, with my 15 years of experience in insurance, we know time after time, where are the most claims every year? It's on disability insurance. That's the most likely thing happening to you, is you're going to claim on your disability insurance before any of the other types of insurance you might have, because it covers such a broad number of things. It's basically, if anything, a medical event occurs that prevents you from performing the duties of your occupation, you can now go make a claim.
Yeah.
No, it doesn't matter what that looks like, whether that's a mental health related, whether that's an illness, whether that's an injury, it doesn't matter. I always have to mention that because I always urge, especially self-employed individuals, business owners, professionals, especially in the part of the world we live in where it's not cheap, have that coverage, because things can get bad really quickly.
Absolutely. Yeah. Yeah. I personally carry both disability and critical illness because
you get
there's no security. There's no security otherwise. I'm self-employed essentially. I run my own practice. And if I don't have these policies in place, then I don't really have an answer to the what if scenario.
No. Very good.
But there we have it, man. Thanks so much for taking the time. Really appreciate it. And I think this will produce a lot of clarity for a lot of people. So